Great.
Everything.
Thank you, everybody, for coming here today for our introduction of the Supreme Court Ethics and Investigations Act. This is unfortunately long overdue, and we have asked the Supreme Court and the Chief Justice numerous times to police itself and to ensure that the general and commonly understood ethics rules that apply to every other judge in this country should also apply to the Supreme Court. But unfortunately, over the last year, we have experienced a steady drip of reporting and information about horrific and really egregious disclosure violations, financial conflicts of interest, and now recently, actual conflicts of interest of the justices with cases that are before them right now and are set to be decided in the next 3 weeks rather. The Supreme Court is facing a crisis of legitimacy today. 58% of the American public disapproves of the Supreme Court. That is an all-time low. And the justices continue to flout basic norms and ethics and standards that have guided judges around the country, around the United States for our entire history. This bill today that we are introducing would create an Office of Ethics and a separate Office of Investigations. This will allow for direly and much needed transparency and accountability. There will be a dedicated Office of Ethics that will have ethics counsel, trained ethics counsel, that would advise the justices on their disclosure obligations and their recusal requirements. The White House and Congress have similar offices to this, and it is commonly used throughout the executive branch. The Office of Investigations would be a dedicated investigative body within the court that would actually investigate allegations of ethical improprieties, disclosure violations, and other ethical issues that may or may not warrant recusal. Because unfortunately, as bad as some of the information about the lack of transparency, lack of disclosure by justices on the Supreme Court, especially Justice Alito and Justice Thomas, we are now learning more and more about how the justices themselves have an interest in the outcome of cases before them. Justice Thomas's wife was involved in the underlying conduct in the Stop the Steal movement leading up to the January 6th insurrection. Justice Alito had a flag that was used by the Stop the Steal movement as an indication of their support for Donald Trump's efforts to overturn the 2020 election, hanging from his house. And he had another flag that's often associated with the extreme right Stop the Steal movement hanging from a different house of his. He alleges that this was his wife's doing. But regardless, the ethics rules do not differentiate between him and his wife in the way that he would have you believe, because that is a conflict of interest. When a spouse is involved in underlying conduct of a case before the Supreme Court, and there are two cases that will be decided over the next few weeks that are fundamental to our democracy. The first is Donald Trump's assertion that he has absolute immunity from any criminal prosecution for any official act that he may have performed as president of the United States, including his efforts to overturn the election leading up and including January 6th. And the Fisher case, which relates to whether or not obstruction of justice statute includes the allegations related to obstructing a congressional act of counting the electoral votes. Both of those cases relate to underlying conduct that Justice Thomas's wife was proved has demonstrated to be involved in, and the political statements in support of that Justice Alito and perhaps his wife, perhaps him, we don't know, because there isn't an Office of Investigations in the Supreme Court that can independently evaluate the allegations against Justice Alito. All we received, and Congressman Johnson and I led a letter of 45 members that Congresswoman Cheryl joined as well, that suggested to Justice Alito that federal law, the Constitution, and basic notions of ethics require him to recuse from this case. Somewhat unprecedentedly, he responded to us, justifying his decision not to recuse, which in and of itself should be an indication that he should recuse to prevent an appearance of a conflict of interest. But what he failed to address in that letter is that the due process clause says that no one can be both judge and jury in their own case. And federal law requires recusal in situations like his, as does the same code of ethics that ostensibly applies to the Supreme Court without any enforcement mechanism. Because if a person could reasonably believe that Justice Alito has a conflict of interest, then he must recuse. But when you look at his letter, he talks about whether or not it is reasonable, whether or not he is correct in his assessment of whether he should recuse, and that's not the standard. But without an independent body that can investigate these allegations and can enforce them, there is no other recourse than for us to initiate impeachment proceedings, which is certainly something that we will have to consider if he does not recuse and he rules on this, on these cases. So I close by saying that we are here, unfortunately, today because the Supreme Court will not police itself. And as Chief Justice Roberts said to the Senate, to Senators Durbin and Whitehouse last week, when he stated that it would be inappropriate for him to meet with them because of separation of powers, we also acknowledge that there are separation of powers and that we, Congress, are a co-equal branch of government with oversight authority over the judiciary branch. Because if there is no congressional oversight authority over the judiciary branch, then the judiciary branch is not a co-equal branch of government. And this bill will provide some sorely needed oversight over the ethical lapses and disclosure violations that have now run rampant on this Supreme Court. And so I'm pleased to be here with our co-lead, Hank Johnson, who's been such an incredible leader on all of the Supreme Court judicial reform work. He's the chairman or ranking member of the subcommittee on the courts. Congressman Johnson, why don't you say a few words?
Thank you, Dan. Great to be with all of you all today. It's clear that we are at a crisis point for the Supreme Court, our country, and our democracy. It's actually a 5-alarm fire. Explosive reporting has shown that special interest donors are buying access to the Republican-appointed United States Supreme Court. Justices are being feeded with private fundraisers luxury vacations, cruises, tuition payments, sweetheart real estate deals, RVs, luxury RVs, and more. And now we're confronted with another justice who is comfortable flying flags outside of his personal residences that were carried by Trump supporting lynch mobs that attacked the Capitol and held a knife to the neck of our democracy on January 6th. You can't make this stuff up, folks. Wealthy special interests have corrupted the supermajority on the Supreme Court, turning the court's operations unethical and its decisions deeply suspect. We now have the best Supreme Court that money can buy. A rigid ideological majority that multiplies the power of the wealthy and privileged while taking away personal liberties from everyone else. All of this, coupled with the Republicans' packing of the Supreme Court with right-wing MAGA extremists, has led to a crisis in public confidence and trust in the legitimacy of the court. Most Americans today have an unfavorable view of the United States Supreme Court. And the fact that the highest court in the land has the lowest ethical standards is not acceptable. The fact that Supreme Court justices are allowed to act as judge and jury in making decisions when their own personal conduct is at issue is no longer acceptable. We need court reform now, and that's why I'm pleased to co-lead the Supreme Court Ethics and Investigation Act, introduced by my good friend and fellow warrior, Dan Goldman, along with other colleagues, including Mikey Sherrill, and also Judiciary Committee Ranking Member Jerry Nadler. This act not only advises justices on ethical matters, but it also provides ethics training and advice to justices and their spouses through dedicated ethics councils. But most importantly, this legislation would also establish an Office of Investigative Counsel within the Supreme Court to investigate potential instances of ethical impropriety by justices and report to Congress on compliance while providing Congress with the ability to submit ethics complaints to the Office of Investigative Counsel, which would investigate and deliver reports on those complaints in a timely manner. We know the issue of court reform is fundamental to saving our democracy and putting out the fires of unethical behavior and questionable conduct by some justices that rages around and threatens to consume the Supreme Court. Thank you, and I look forward to continuing to raise awareness of these critically important issues on what steps we can take to fix this court so it's no longer unethical and unaccountable to the American people, and so that we can restore the precious and delicate system of checks and balances that has been thrown out of whack by a United States Supreme Court that has seized legislative and executive power for itself. And when partisan politics dictate that it should or it can. And with that, I'll turn the microphone over to our ranking member of the Judiciary Committee, Jerry Nadler.
Thank you, Hank. I'm proud to join Congressman Goldman and our colleagues, Mikey Sherrill and Hank Johnson, in introducing the Supreme Court Ethics and Investigations Act. This legislation is essential to helping restore the public's trust in one of the nation's most vital institutions. The Supreme Court's fidelity to equal and impartial justice, as well as the public's faith in the judiciary's integrity, are foundational to maintaining the rule of law. But public confidence in the court has plummeted to an all-time low. Justice Alito's display of a flag supporting the so-called Stop the Steal movement suggests a blatant conflict of interest as the court considers cases related to the January 6th insurrection and the 2020 election. Although the Supreme Court imposed a code of conduct, so-called, upon itself late last year, Justice Alito has declared that he has no plans to recuse himself, as those standards would clearly demand. Because there's no way to enforce these basic ethical strictures, the rules may as well not exist. And Justice Alito is not the only Supreme Court justice whose impartiality can be called into question by a reasonable American. Justice Thomas, in at least two different ways, has shown his conflict of interest. His failure to disclose numerous extravagant trips and gifts funded by billionaire GOP mega donors has demonstrated the immediate need for the same binding code of ethics as is followed by all other judges in the United States. And his wife's involvement in the Stop the Steal movement and his refusal to step aside from considering January 6th related cases violates the appearance of impropriety and shows again the need for the same binding code of ethics that is followed by all other judges in the United States. That is why this legislation is so important. By embedding ethics counsels and investigators within the court, we can ensure that our nation's highest court is adhering to the highest standards of ethical conduct. We should expect no less from the justices, but their conduct, too, often falls short. With the Supreme Court Ethics and Investigations Act, we can ensure that justices are held accountable for their actions and help rebuild the crumbling respect for our nation's highest court. Thank you.
Thank you, Ranking Member Nadler. Now I want to introduce Congressman Mikey Sherrill from New Jersey, who's also a co-lead on this, a former prosecutor and somebody whose voice has been so strong on these issues.
Thank you. Thank you so much. After spending almost a lifetime in public service, both in the United States Navy and at the U.S. Attorney's Office in the District of New Jersey, the office which at one point Justice Alito presided over as the U.S. Attorney, we were often trained in our responsibilities of public service. So it wasn't simply that we didn't act with impropriety. We had to act in a way that no one would suspect impropriety from our actions. So it wasn't just impropriety, it was also the appearance of impropriety. And here we have both, sadly. We have justices who have reportedly received money and gifts and travel. We have justices who have shown themselves not to be unbiased in their determinations of how they feel about the election, flying flags that are related to the Stop the Steal movement, flying flags related to right-wing Christian nationalism, and then hearing those cases and refusing to recuse themselves. And so while I know, because I served in that office, that at one time Justice Alito received ethics training, he's obviously due for a refresher course. And that's what this bill would do, to make sure that justices and their spouses receive training on their ethical responsibilities, to make sure that should they not follow that training, that an independent organization can investigate that, as we do with so many of our government agencies, because obviously the court has not been able to police itself. You know, throughout my service, both at the U.S. Attorney's Office, in the United States Navy, and once again in Congress, I took multiple oaths to the Constitution, and our justices take oaths to the Constitution, but with one very particular difference. They swear to administer justice without respect to persons and do equal right to the poor and to the rich. The public needs to know that they are going to fulfill that obligation. The public deserves to know whether or not they can do so impartially, and that's what this bill would ensure. Thank you.
Thank you very much, Congresswoman Sherrill. We're also honored to have here today a number of court reform groups, the pro-democracy groups who have endorsed this bill and are here to say a few words. Given that we do have votes shortly, I would ask them to keep their remarks brief brief if they could. And first up, I want to introduce Gabe Roth from Fix the Courts, who was an incredible partner in drafting this legislation.
Thank you, Congressman Goldman, Congressman Johnson, Congressman Sherrill, Congressman Nadler. Thank you all for coming. This is a critical bill, and the way I look at it is it sets a level of consistency across what is going on right now in the building behind me. Right now, we have this hodgepodge of how justices view their ethical requirements. Some ask their colleagues about conflicts of interest. Some ask law professors. Some ask the Office of Legal Counsel, not the one at DOJ. They have an Office of Legal Counsel too, though who knows what they do. They look at legal treatises and talk to the Codes of Conduct Committee and the Judicial Conference, or they talk to no one. They just do whatever they want to do. But that's far from a best practice, and this bill would change that. My second point, the fact that the justices serve for life and they have no ethics training requirement is ridiculous. The Federal Judicial Center down the road has training modules on harassment, workplace conduct, conflicts of interest, 28 U.S.C. 455, and the justices are not required, whether they serve for 15 years or, as is happening more frequently, 35 years. There's no requirement that the justices show up to a single one of those training events. If you're on the Supreme Court of Hawaii, every year you have to show up to ethics training, every single year, and you have to affirm that you've attended ethics training on your financial disclosure report. So this ethics training requirement is critical. My third and final point is that personnel is policy. Right? If you add up the salaries and look at the text of the bill, I'm sure it's Damon and other folks in Arturo sent it to you all. Look at the text of the bill. If you add up all the money, it's talking about 1% of SCOTUS's $150 million budget, spending it on internal mechanisms to improve ethics. Is that too much to ask? 1% of SCOTUS's budget towards improving the ethics rules, the ethical oversight, the ethical council? I don't think that that's asking too much. And so that's what this bill would do. And I just want to say, I'm very appreciative that members, at least on one side of the aisle, are pushing towards this. And there's nothing partisan about the bill, of course. But so long as the Supreme Court is having difficulty policing itself, then we need Article 1 to assert its power and help them help themselves. Thank you.
Thank you, Gabe. And Gabe references 28 U.S.C. 455, which everybody should look up. That is the federal law that governs recusal for all judges, including justices. And it is the law that Justice Alito and Justice Thomas are in the process of violating as we speak, as they consider two cases from which they must recuse. Next, I want to introduce Abe Rakoff from End Citizens United. Has been a great partner as well. Abe.
Thank you all for being here. Thank you for all your work on this. There's no denying it. The Supreme Court is in a state of crisis. After watching the impact that corruption has had on our freedoms and our democracy, the American people have lost faith in the judicial system. And who can blame them? Over the last year, we watched ethics scandal after ethics scandal, followed by zero accountability. It's unacceptable, and we can't let them get away with it. The Supreme Court should be the gold standard for our judicial system, not the corrupt mess it currently is. End Citizens United and Let America Vote is a grassroots organization with over 4 million members, and we're dedicated to rooting out corruption in government and protecting the freedom to vote. We're proud to work with these members of Congress to have that same level of oversight for the Supreme Court as everyone else. This legislation is a vital step to rebuild Americans' confidence in the Supreme Court. We're grateful for all the work of the members for signing this on. When this bill becomes law, the Supreme Court justices will be held accountable for ethical lapses for the first time. It will guarantee a code of conduct is properly followed and actually enforced, bringing this court in line with all other federal judges across the country. And Americans will have confidence that ethics violations will be investigated to the fullest extent and that there will be real accountability. Simply put, this legislation will ensure that the Supreme Court works for everyday Americans, not the wealthy elite or the corrupt special interests. So thank you, members, for introducing this critical legislation and for your tireless efforts to bring this meaningful reform to the court. On behalf of the 4 million members of End Citizens United and Let America Vote, we urge Congress to wake up to the crisis at the Supreme Court and pass this bill right away. Thank you.
Thank you, Abe. Next up, I would like to introduce Caroline Saccone from Accountable US, the president of Accountable US.
Hi, thanks so much. I'm Caroline Saccone, president of Accountable.us. We're a government watchdog that exposes networks of power and influence, pulling the strings at institutions for their own benefit. And there's no better example of that than the recent Supreme Court. I'm grateful to be here and want to thank Representative Goldman, co-leads Hank Johnson, Cheryl, and Nadler, and other co-sponsors and our partner groups here for this important initiative. We know that there's an ethics violations and corruption crisis at the Supreme Court, which is why we're here. Just in the last couple of weeks, we have seen some startling examples of the undermining of the justices' credibility. And that is why public trust in this court is at all-time lows. And that has really been at the result of a coordinated effort to put far-right extremists and special interests over everyday Americans. And the American people are seeing that, and they're watching, and they've had enough. So we're very excited to support the Supreme Court Ethics and Investigations Act as a solution to this issue. And, since ProPublica had broke this ethics crisis a year ago, we've seen so many examples of undisclosed celebrity travel, unusual perks that have surfaced, many involving Leonard Leo, who has been the architect of this court and also this corruption crisis. This is not normal. I think we have to remember that. And as we've heard earlier, there are mechanisms that are in place in other parts of the government that can be put in place now, and that's why this bill is such an important initiative, and it will help investigate and hold these justices accountable. The stakes could not be higher. There are new crises that are emerging. It feels like almost every day. There have been a number of disastrous and unpopular decisions that we have seen come out of this court. And we just can't trust which side some of the justices are on anymore because of the incredible conflicts that we've been seeing. But we really can change this reality, and this bill will help us get one step closer to a level of transparency, accountability, and a higher level of ethics that the Supreme Court needs. Thank you very much.
Thank you, Caroline. Next up, Joe Van Wy, who's the senior legislative strategist at Peachtree.
Thank you, Representative Goldman, Ranking Member Johnson, Ranking Member Nadler, Representative Cheryl, and everyone gathered here fighting to reform this broken Supreme Court and to establish these critical offices for ethics and investigation. I, along with everyone else gathered here today, am here to say the Supreme Court is increasingly corrupted and faces a serious legitimacy crisis. It needs reform, starting with real ethics rules and a dedicated body to investigate ethical violations. More than half of the United States no longer has confidence in this court, and for good reason. These unelected justices, corrupted by big money and far-right influences, are imposing their agenda on the American people. Currently, the people behind us, each of whom serves a lifetime term, hold in their hands the fates of millions of Americans. And it feels like every week we are faced with another ethical lapse or violation that should merit recusal. 2 of the dozens of cases currently under review by the Supreme Court, for example, could entirely upend our executive branch. The far-right activists on this court have been working to completely dismantle our regulatory state for years. In Relentless and Loper, anti-government corporate actors are working to overturn Chevron deference, a fundamental judicial principle that allows these experts to, at the direction of Congress, make rules and regulations. Many of the Republican-appointed justices on this court, however, have made it painfully clear that they are not only willing but ready to throw out this important statute deference entirely. This would be a signal to extremist judges across the country that it is now open season on the many protections put in place at the direction of the people's representatives. Without this critical principle, experts would no longer be in charge of executive policy decisions. Instead, folks like the Fifth Circuit's James Ho, who held his swearing-in ceremony in Harlan Crow's personal library and has overturned a host of common sense laws and regulations, will be in charge of implementing a huge amount of federal policy. It turns these judges into policymakers and empowers activist judges to pursue the radical and partisan agendas, putting hundreds of vital protections on life support. But that's not all. Over the next few weeks, these justices will issue rulings that determine whether we will protect reproductive health care, whether those experiencing homelessness will be treated as equal members of society, whether we can effectively tax the uber wealthy, and whether we will hold criminal insurrectionists and Donald Trump accountable for their actions. The legislation being introduced today, which P Street is proud to support, takes this court's upside-down ethics and begins to turn them right side up. Advocates will continue to carry that flag, along with the representatives here today, the co-sponsors of this bill. The Supreme Court is increasingly corrupted and faces a real legitimacy crisis, but this legislation marks the first step towards making it legitimate again. Thank you.
Thank you, Joe. Last but certainly not least, Jessica Reddy-Bender, Senior Advisor at Court Accountability. Jessica.
Good afternoon, everybody. My name is Jessica Brady-Reeder. I'm a senior advisor with Court Accountability. I want to thank Congressman Goldman for having us today and all of the colleagues and the staff who worked hard to get this bill introduced. I would just associate myself with all of the remarks that we've heard today. There's really nothing to add. I just want everybody to remember to leave with this important detail that all of the ethics scandals that you've heard and the clear bias of the justices, there is no real teeth in any code of ethics that they have to follow. This bill would help to achieve that. Holding the judiciary accountable is not just Congress's constitutional duty, despite what you may hear. It's what the American people expect from their leaders in Washington. If a Supreme Court justice commits an ethical or legal violation, they should have to answer for it. And this bill is an admirable step towards achieving that standard. Thank you so much for having me today. Everybody go back inside and get cool. Thank you.
Thank you. We can open up to a few questions. If anyone has anything.
One of the most common criticisms of this bill and some of the others that authors that it opens up the Supreme Court to gamesmanship. Litigants filing lawsuits strategically to kind of pick off certain justices and try and dictate the results. I was wondering how you respond to that concern.
No, this bill actually would prevent that. First of all, it's the complaints for violations are not open to anyone. So we wouldn't expect a flood of complaints, that there's a restricted category that can make the complaints. But more importantly, there is an independent investigative office that will investigate any of these credible allegations. And so this, it's a shame that this has become a partisan issue, because there's nothing partisan about this. This applies to every single justice, no matter what their background is, no matter what party appointed them, no matter who they are. And this is just good government. This is democracy. This is protecting the rule of law and making sure that those who are deciding our most important cases are doing so with the confidence of the American people. And you cannot have confidence if you have an appearance of a conflict of interest, or if you're receiving undisclosed benefits from parties that appear before you. This is basic stuff. This is not complicated. And the fact that we are actually dealing with this belies the argument that there's any gamesmanship here. There's no gamesmanship. This is egregious to anyone on any side of the aisle, and nobody should support this kind of partisanship that we're seeing in the court. This bill is not partisan, and this bill is designed to remove the partisanship that we are now seeing in the court.
Part of the criticism of the current system is that there's no mechanism for their code. How would this bill enforce the code, enforce action against those that breach ethics?
Well, the bill requires the Office of Investigations to send a report to Congress for any credible violations that they find. So sunlight is the best disinfectant, and that will require transparency. It will require both the Congress and the American public to see what the independent investigators found, and either Congress can take action, this court itself can take action, but we will get to the bottom of whatever the allegations are, unlike what we have seen, which are sort of self-fulfilling, self-righteous, self-justified explanations by the justices themselves without any investigation and without even addressing a lot of the allegations or much of the investigation, the independent investigations done by journalists. And what the responses beg far more questions than provide answers. We welcome Republican support. As I said, it is a shame that basic common sense judicial ethics seems to have become a partisan issue. And it is part of the extreme MAGA right's attack on democracy. It is an attack on the rule of law, and that's what these justices are doing and supporting, and that's what this bill will prevent. You guys want to say anything else? All right, thank you very much.
Great. Jerry, take it away.